Hello, and thank you for listening to this podcast. My name is Karen Killaley. I am a partner and head of the employment team at Maples and Calder, Ireland, the Maples Group's law firm in Dublin. I have some housekeeping to cover off as usual. If you are listening in from your podcast app, you'll find any resource documents and speaker information in the description. If you've clicked on the media player link sent to you by email, then you can find this information in the notes section. Please note, as always, this podcast contains a general overview of the law relating to the Irish transfer regulations, including key principles, examples of their application to help illustrate these principles, and some related issues which may be of interest to listeners. It does not constitute legal advice, and if you have a specific situation or question, please seek tailored legal advice from us. Last but not least, please don't forget to subscribe on Apple Podcasts, Spotify, or wherever you get your podcasts from. So again, I'm joined today by my colleague, Kieran Lungig, who is an associate on the employment team here at Maples. Before we get started, let's talk about language. So you will have seen the title of our podcast today is the Irish Transfer of Undertakings Regulations, Key Principles and Application in Ireland. When we refer to the Irish transfer regulations in this podcast, we will refer to them as TUPE. So TUPE is a term very commonly understood by employment lawyers and HR professionals in the UK and in Ireland, but we are aware that we do have listeners beyond those jurisdictions, and that term is probably not very frequently used outside of these jurisdictions. So sometimes the abbreviation ARD is also used, so it's interchangeable with TUPE. ARD refers to the Acquired Rights Directive, and that is the directive, the most recent one, which dates back to 2001, and that is the source of employees' rights and employer obligations on the transfer of a business. So you'll hear us refer to TUPE today, and that is what we're referring to. We come across the application of TUPE quite frequently, and as there is a definite uptick in transactional activity generally across the market, we thought it might be helpful to look at why TUPE, or transfer regulation considerations, are important considerations for employers in Ireland, where a change of ownership or a change of control or a change of corporate structure perhaps is planned. And likewise, if a business is looking to dispose of a significant asset or assets, these are all situations where employers, and in particular the HR team in Ireland, may have to ask themselves, does TUPE apply here? In other words, could this give rise to a TUPE transfer? So in today's podcast, we thought that it would be useful for employers and HR professionals and in-house counsel if we provided a summary of the principles of TUPE. We'll provide a recap of where TUPE applies, which might not be so obvious to listeners, and we'll also talk about some additional pieces to bear in mind when considering TUPE. As a general starting point, this is a topic that is complex, and I think it's safe to say that many lawyers and HR professionals have been left with sore heads trying to work through and understand the complexities and nuances of TUPE. And it's important to remember that although TUPE does derive from the Acquired Rights Directive that I mentioned, it does actually operate slightly differently across different jurisdictions. Today, we're talking about Ireland, and we're talking about how TUPE operates in Ireland. After that rather lengthy introduction, Ciara, I'll hand over to you, and can you just give us an overview of TUPE?
Sure, Karen. So as many of our listeners would know, the European Community's Protection of Employees on Transfer of Undertaking Regulations 2003, or TUPE, as we said, apply automatically by operation of law. Article 3 of the TUPE regulation states that TUPE applies in respect of any transfer of an undertaking, business, or part of an undertaking or business from one employer to another as a result of a legal transfer, including an assignment or forfeiture of a lease or merger. In other words, when an undertaking or part of an undertaking is transferred from one owner to another, the employees attached to that undertaking automatically transfer from the old employer to the new employer. The key principle is that a change of ownership or responsibility for work should not interrupt an employee's rights. Employees have special protection against dismissal and protection against changes to their terms of employment in connection with the TUPE transfer. TUPE is intended to preserve and protect employees. These employees transfer with their accrued years of service, their existing terms and conditions of employment, subject to the exception of pensions, and the benefit of any collective agreement which may apply to them. If TUPE applies, the new employer steps into the shoes of the old employer, and the responsibilities of engaging the employees passes to the new employer. It's important to note that due to the European origins of the TUPE regulations, a number of the key guiding cases when it comes to interpreting TUPE's application in Ireland come from European case law. And is well established in both European and Irish case law that the aim of the European directive is to ensure continuity of employment relationships with an economic entity, irrespective of any change of ownership. And this is found in the seminal Susan decision.
Thanks, Ciara. And we will come back to the Susan decision and some other of the key cases in a few moments. Just to recap, the significance of the Irish TUPE regulations applying to a business transfer, we're also going to talk further about that in a moment, can probably be summarised as follows. First of all, if TUPE applies, it confers significant rights to information and consultation on employees in advance of the TUPE transfer. So the transferring employees or their representatives, as the case may be, are entitled to information regarding the business transfer, such as the date of the transfer, the reasons for the transfer, and whether there are any legal, social, or economic measures envisaged in connection with the transfer. It might also be necessary to consult with the transferring employees. It's not always necessary, but it may be. And it will be necessary if there are measures envisaged. And what that typically means is if, for example, there are changes to the terms and conditions of employment envisaged after the business transfer. It is important to remember that the information and or consultation exercise will need to be conducted at least 30 days before the date of the business transfer, or in good time where 30 days is not reasonably practicable. So there is a little bit of flexibility there, but generally as a rule of thumb, that information and consultation exercise needs to start 30 days out from the date of the transfer. Finally, important to note a couple of other pieces. Dismissals in connection with a TUPE transfer are prohibited. And also good to recall that employees are not obliged to transfer as part of a TUPE transfer. They have a right to do so, but they can also refuse to transfer. So we've talked a little bit, and I've kind of used the terms interchangeably, business transfer and TUPE transfer. Ciara, would you just talk us through what exactly constitutes a TUPE transfer? What are we talking about here?
A TUPE transfer applies if there is a sale of a business as a going concern, which retains its identity post-transfer. And importantly, this can also apply where only part of a business is being sold off or contracted out. A transfer of part of a business can be considered as a TUPE transfer, where that part constitutes an economic entity. The economic entity is an organized group of resources. So in general terms, if a business is taken over by another employer as a result of a legal merger or transfer, the rights of the employees are protected by the TUPE regulations.
Perfect, thanks. And many of the terms that you've used there, such as transfer, economic entity, identity, they're all terms of art, and they're either defined in the Irish TUPE regulations and indeed the Acquired Rights Directive, and or they have been the subject of extensive case law. So in summary, what can trigger the application of TUPE is where the entirety or a part of a business, which has its own organizational cohesion, such as it being a division of a business with its own P&L or its own defined teams, and generally an identifiable structure where that is transferring somewhere else and there are employees attached to that business. So that's when I suppose the antenna need to be up and you need to be thinking about TUPE and whether TUPE can apply. So I suppose we need to bear in mind that even very, very small businesses with just one employee could constitute an economic entity for the purposes of TUPE. And in fact, much of the key case law in this area dating back to the 1980s and the 1990s relates to businesses such as security businesses and contract cleaning businesses, where in fact there was only one employee assigned to the transferring business. So the scale of the business is not really a determining factor. It's really that sort of organizational structure, and then what is happening to that business on the other side of the transaction. Is it more or less going to continue operating in a similar fashion? So I think important to bear that in mind. Kira, can you just talk to us a little bit about the business retaining its identity?
Yes, absolutely. Whether an entity retains its identity will be a question of fact in each particular case. EU case law has set out some factors which need to be looked at in terms of determining whether or not there is a transfer of an undertaking which retains its identity, and uses what is described as the going concern test. So some of the factors include, for example, has goodwill in the business been transferred? What activities were carried on before and after the transfer? What is the extent of any disruption to those activities? And will the buyer be seeking to use the employees going forward?
Okay, that makes sense. And as always, I think it's useful to try to provide some examples of where TUPE applies. And I know we're going to dive into that in just a moment. But I think when people think of TUPE, the usual example that comes to mind is where a business has been acquired via the sale of the assets of a business. So it's a relatively straightforward asset transfer. This is distinct from a share sale where there is a change of control, but not necessarily a change of employer. So the basic position is that TUPE does not apply to a share sale, and that remains correct, except, as we will see a little bit later, sometimes that can be too simplistic an analysis, and we have to remember that even if it's a share sale, there may be employees elsewhere within a corporate group who are supporting that business that is the subject of the share sale. I always find it's helpful to remember that a key part of TUPE is that the impacted employees experience a change of employer. So TUPE's classic application to a business transfer means that the existing employees of the company transfer from the old employee, who we call the transferor, to the new employer, who is the transferee. And in this situation, the transferring business will continue to perform the same functions post-transfer as it did pre-transfer. So it's all very straightforward, but that is definitely not always the case. So Kira, do you want to take us through some of the principles?
Yes, no problem. And it's worth taking a closer look at the seminal case of Spykers. So this case involved Mr. Spiker, an employee who in a slaughterhouse where the business activities of his employer had ceased for 3 months before the business assets were purchased by a new company and the business activity commenced again. The case made its way to the European level, where the ECJ agreed with the High Court of the Netherlands in that the business activity which the new employer carried on was the same kind of activity previously carried out by the older employer, and the transfer of the business assets enabled the new employer to continue the activities of the old employer. Therefore, a TUPE transfer had taken place, and although Spykers is now nearly 40 years old, it has been well established and frequently cited case law in the Irish courts ever since.
Indeed, and we're all familiar with the famous Spykers test. So the Spiker case that you just mentioned has been a source of clarification, as you say, for more than 3 decades, I suppose, at this stage. And it usefully summarized the tests as to what you need to look out for as part of a transfer to establish whether TUPE might be triggered. And those tests include, have the business's tangible assets transferred? So tangible assets would be, buildings, equipment, and so forth. How about its intangible assets? Have they transferred, and what is their value? Have the majority of employees transferred to the new employer? Our customers, our policies, our customer contracts transferred? And then, as you mentioned earlier on, just a few moments ago, does it retain its identity? What is the degree of similarity between the activities carried out by the transferor and the activities carried out by the transferee? So as with everything that is TUPE related, the facts are so, so important. It's really important to understand, what does the business do? What are its assets? What's the value of those? What do people think is going to happen to the employees? What's going to happen after the transfer? all of that needs to be interrogated. But as we flagged just a few moments ago, it's not always straightforward to spot TUPE. And you have some examples, Ciara, of how TUPE might apply in situations where at first blush it might seem it has no relevance whatsoever. So do you want to talk us through those?
Yes, absolutely. Our first example relates to property transactions, which we see quite a bit in practice. So it's important to remember that where a lease or a tenancy agreement in relation to a property is being signed to another party, or simply reverting back to the original landowner, or indeed where a property is simply being sold, TUPE can actually apply to that transaction where there is a transfer of an economic entity triggered by or contemporaneous with that transaction.
Yes, and it can also happen in a situation where, so as opposed to a trading business at that property, it can also happen if there's an employee or employees engaged at the property, for example, as security personnel or at reception or contract cleaning, or as we very frequently see in practice, employees who are engaged by the building manager. So the contracts under which those employees are engaged, in other words, the service provider contracts may come to an end because of that sale. So the building is sold and there is a decision to perhaps change the security provider, change the reception provider, or change the building manager. And that can happen because there is a sale or a reversion of the lease or an assignment of the lease. And really, you have a new lessee or a buyer deciding to put their own service providers in place. And in that situation, it is extremely important to ask whether TUPE could apply. And frequently, this can be a little bit downstream in the transaction because neither the buyer or the seller may necessarily have any employees attached to the property at all, but their service providers might. And it is possible that any liabilities associated with the breach of TUPE could flow back up. So really, this means that the fact of TUPE applying has to be considered, and it may need to be reflected in the transaction documents related to that disposal of the building or the real property asset in order to manage legal and cost risks associated with any breach of TUPE. And asking the question as to whether TUPE applies at an early stage in these transactions also facilitates the transferor and the transferee, which, as I say, might be a little bit downstream in the transaction. It facilitates them complying with their obligations under TUPE. So as you've pointed out, it may not necessarily be obvious immediately when that type of transaction is being contemplated, but it's very important just to ask the question, are there employees associated with this asset and what is happening to them post-transaction? Ciara, any cases which you want to talk about, which kind of explain the practical implications of this?
Yes, two particular cases of note that we thought would be helpful to discuss today. So the first case is the Darcy decision, which involves an employer operating a cafe restaurant under a lease. The business was in rent arrears and the landlord commenced bankruptcy proceedings against the employer. On 4th of February 2011, the employer informed the staff that the landlord was repossessing the unit, and one of the employees raised the issue of TUPE. The employer contacted the landlord and impressed upon him that if he intended to reopen the restaurant in the same premises, a TUPE transfer would take place. The landlord repossessed the unit on the 7th of March 2011, and in this case, the landlord's repossession of the unit was held to be a TUPE transfer. The second case we thought it might be helpful to take a look at is Collins v CNL Na Fianna from January 2022, where the WRC considered claims by employees of a company, CGM, who had previously provided services to the RCSI in relation to one of their sports grounds. The respondent, CLG Na Fianna, entered into a lease with RCSI for the use of the grounds. A number of employees of CGM, the previous service provider, argued that the services provided by CLG were the same as CGM and their employment should have transferred. The WRC disagreed in this case and determined that the complaints were not well founded, as the new arrangement between the college and CGL had not maintained the previous identity of the economic entity that was CGM, and as such, a TUPE did not apply. As such, it's a key consideration for that the business that is transferred along with the lease is one that retains its identity, and this is decisive when considering whether TUPE does apply.
Thanks very much for that. That's very helpful. And I should say that we'll have a copy of both of those decisions in the show notes. We will also put in a copy of the Irish TUPE regulations, and for good measure, we might even include the Acquired Rights Directive. So plenty of reading. Could we also look at one other issue, which is change of service provider? And how different TUPE regulations cater for change of service provider provisions changes across different jurisdictions. So let's talk about Ireland, Ciara. Can you just tell us how TUPE might apply in Ireland to a change of service provider?
So TUPE can indeed apply in the case of service provision change. For example, when a service is outsourced, retendered, or taken in-house, anyone who's part of an organized grouping of employees providing that service to the end user, otherwise known as the client, could be protected by TUPE. For instance, if a client decides to change the cleaning company that it uses from company A to company B, those people originally employed by company A as cleaners for the client could transfer to company B under TUPE.
Yes, and it's not always the case, though, as we will see in just a moment. And we also know that there are no specific change of service provider provisions in the Irish TUPE regulations as there are in some other jurisdictions. So the position in Ireland is where there is a change of service provider, as you've just explained, then there always needs to be an analysis as to whether TUPE applies. So could you talk us through the key principles that apply to that situation? So it's a change of service provider situation, please.
Yes, the key reference point is the Susan case, which you mentioned a little bit earlier on. So in the Susan case, the court held that a change of service provider will not trigger a TUPE transfer unless there's an associated transfer of assets of the business or the taking over of a major part of the workforce. The court held that TUPE did not apply to that particular service change, given that there was no associated business transfer of significant tangible or intangible assets. Further, there was no taking over by the new employer of a major part of the workforce previously performing the service for the contracting authority. There was a distinction made in Susan between asset reliant and labor intensive services. So TUPE is more likely to apply in an asset intensive business where the assets have transferred. Likewise, TUPE is more likely to apply to a labor intensive business where the majority of the workforce has transferred. More recently, this issue of whether TUPE applies to a service provision change was considered in the decision of the Minister for Employment Affairs and Social Protection versus Dunn. So in this case, the court considered the situation where an individual called Miss Heffernan was contracted by the department to provide a service as the manager of a social welfare branch office in Edenderry. Miss Heffernan had provided the premises, facilities, and staff to deliver services relating to the distribution of social welfare payments. Miss Dunn was an employee of Miss Heffernan until Miss Heffernan retired, and the services were transferred to and subsumed into the range of services provided by the Minister's Department at its office in the town. The department informed Miss Heffernan that the TUPE regulations did not apply to her staff, and Miss Dunn lodged a claim with the WRC, which upheld her complaint, as did the Labour Court on appeal. The High Court had the final say on the matter, and they ruled that TUPE did apply to this service provision change. The High Court agreed with the Labour Court that significant tangible assets, including the data of the recipients, essential for the performance by the social welfare branch office, were being transferred in the business transfer that had taken place, and therefore TUPE applied to this particular service provision change. The distinction made in Susan between asset and labour reliant services was considered by the High Court in this case to the extent that, due to the service being reliant on data of the social welfare recipients as a significant tangible asset in an asset reliant service, TUPE was held to apply here, and so the employee had a right to transfer.
Thanks, Ciara. That's all very clear. But as is always the case with TUPE, there is a slight complexity, and there is a distinction in the case law between, on the one hand, a change of service provider that we've just talked about, and you've given some examples from the case law of this, which does constitute a TUPE, and between situations where a business is deemed to have simply lost a contract. So maybe contract cleaning or security or reception services, as we talked about earlier. It's not always the case that when there is a change of service provider, there is a TUPE. There is a different category of transfer, if you like, which can be described as a mere loss of a contract. So does TUPE apply where there is a mere loss of a contract?
Well, this answer will depend on a number of factors, and it's true that the set of circumstances you describe involve a service provision change as such, and there is a transfer of an economic entity. However, as established under case law, no one element is decisive, and a number of factors must be looked at, and the degree of importance to be attached to each and to any one criterion will necessarily vary according to the activity carried on, or the production, or the operating methods employed in the undertaking. The mere fact that one economic entity takes over another economic entity is not a ground alone for concluding that the latter has retained its identity.
Yes, and as I say, I think that the more you discuss TUPE, the more it can become a little bit frustrating because sometimes the answer to the question, well, does TUPE apply or does it not, is, well, it depends. And as mentioned, we need to look very, very carefully at the specific factual situation. So in short, I think in each particular situation, the employer needs to assess whether there is actually a TUPE transfer or whether there has been a mere loss of a contract. In other words, is it a situation where there is not, in fact, the required organizational structure such that the business is not actually a transferring business or a transferring economic entity? It is simply one contract for work which has been lost, and it might be one of many contracts which the employer wins and loses on a weekly or monthly basis. So again, I sort of take the example of perhaps like a contract cleaning type of business. So what does the case law tell us here? Could you provide a couple of examples to illustrate this?
Well, in Susan, the court stated that the mere fact that the service provided by the old and the new awardees of a contract is similar does not necessarily mean that the economic entity has transferred. But it's also worth considering the recent Irish case of contract cleaning operative versus contract cleaning service provider, where the respondent former employer of the complainant was found to have incorrectly assumed that should be applied to his employee. This was incorrect because the WRC found that there was, in fact, no transfer of assets of any kind between the outgoing and the incoming contractors. The WRC found that the mere loss of a service provision contract without the necessary Susan ingredients, so to speak, including a transfer of significant assets or labour. Instead, the WRC decided that the complainant should have been made redundant and received their statutory redundancy payment.
Thanks, Kira. And we will put a copy of that decision in the show notes as well. As you said, it's quite a recent decision. So when the TUPE, the Irish TUPE regulations apply, the obligations are, as you already mentioned, to ensure that employment is protected and that the terms and conditions of employment remain the same. So they're not varied in connection with the TUPE transfer. There's also an obligation on the transferor to conduct an information and consultation exercise. There's also a little known obligation on the transferee. Well, I wouldn't say little known, it's more that it's little used. There is also an obligation on the transferee, which doesn't tend to be triggered so much in practice. But in any event, what are the consequences of a breach of the TUPE regulations?
Well, as you said, both the transferor and the transferee have obligations to provide certain information about the transfer to employees and to consult with them no later than 30 days in advance of the transfer. And failure to do so can result in the employee receiving an award of 4 weeks remuneration. The employees transfer to the transferee and are entitled to retain the same terms and conditions as applied before the transfer, as you said, and the employees retain their continuity of employment. The transferee becomes liable for obligations which accrued to the employees before the transfer and were not discharged. It's also worth noting that a dismissal in connection with the transfer is an unfair dismissal, and redress of up to 2 years remuneration, re-engagement or reinstatement can be awarded in those instances.
Okay, that's great. Thanks for that, Kira. I think we've really just exposed the tip of the iceberg here in relation to TUPE, and there's so much more we could talk about. But I think the purpose really of today's podcast is just to remind employers in Ireland of the existence of the TUPE regulations, to be aware when there is a transaction of a business or an asset, to which employees are assigned or attached, that you just need to ask the question, could the Irish transfer regulations apply to this? And just a few other takeaway points for employers in Ireland on this subject. First, it's really important to get the information and consultation exercise prepared and ready in good time before it is due to start, as it can take quite a lot of time to collate all the information that is needed in order to inform the employees properly and to consult properly with the employees as necessary. The second point that we would make is, as a transferee employer, so you're receiving in the transferring employees, you will need to consider how you are going to integrate the new population of employees on their existing terms and conditions of employment. And that can be a little bit challenging, particularly where those benefits are different and the benefits platform just operates differently. We need to bear in mind variations of terms and conditions of employment in connection with TUPE are not permitted. So it's important that where variations are made, at the very least, that those variations are not unfavourable to the transferring employees. We don't really have time to touch on the exclusions from the application of TUPE, some of which are significant. We also haven't really had time in this podcast to talk about how you manage and deal with the liabilities arising from TUPE in transactions. But let's just mention for completeness, in terms of transactions, some transactions are excluded from the application of TUPE, and principally that relates to insolvency situations. So many court-supervised insolvency situations fall outside of the scope of TUPE, so need to bear that in mind. I would also just mention that, and you touched on this earlier, Ciara, but in terms of benefits, the rights connected to participation in an occupational pension scheme may not transfer under the Irish TUPE regulations, but the position should be checked to determine if there are any contractual rights which are in fact capable of transfer and which do not fall within the pension exclusion. So it's just worth bearing that in mind. So it's a complex legal area. We will have some resources in the show notes, which will hopefully be of assistance. And we will have the Acquired Rights Directive and the regulation. So it'll be at least of some assistance for listeners who want to do a little bit further reading on TUPE and whether or not it might apply to a business transfer. For now, thank you for listening to the Maples Group Irish Employment Law podcast. If you've any questions or queries on any of the points covered today or on Irish employment legal issues in general, please do get in touch with us. Thanks for listening and subscribing.